This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So let's take a look at what has happened here with the South Bay United Pentecostal Church. They are suing Gavin Newsom, governor of California, and it has somehow made it all the way up to this Supreme Court of the United States. This is Chief Justice John Roberts' concurring opinion. And then there's a dissent too. And since this is only a couple pages long, let's take a look at the dissent too. This is an application for injunctive relief presented to the court, and it is denied. And here is the court's opinion, and this is Chief Justice Roberts concurring in denial of application for injunctive relief. The governor of California's executive order aims to limit the spread of COVID-19, a novel, severe, acute respiratory illness that has killed thousands of people in California and more than 100,000 nationwide. Do you remember only a few short weeks ago, people were saying, but the flu kills 30,000 people a year? At this time, there is no known cure, no effective treatment, and no vaccine. Because people may be infected but asymptomatic, they may unwittingly infect others. The governor's order, places temporary numerical restrictions on public gatherings to address this extraordinary health emergency. State guidelines currently limit attendance at places of worship to 25% of building capacity, or a maximum of 100 attendees. Applicants seek to enjoin enforcement of the order, or they seek a court order overturning the governor's order. Such a request demands a significantly higher justification than a request for a stay, as in a stay of a case, or a stay of an order, because unlike a stay, an injunction does not simply suspend judicial alteration of the status quo, but grants judicial intervention that has been withheld by lower courts. This power is used where the legal rights at issue are indisputably clear, and even then, sparingly. It's used sparingly, and only in the most critical and exigent of circumstances. Although California's guidelines place restrictions on places of worship, so places of worship are covered by the First Amendment, and the First Amendment prevents Congress from making laws which abridge the practice of free practice of religion, or establish a religion. So they are also not allowed to make laws that establish one religion. So did they do that? No. Justice Roberts says those restrictions appear consistent with the Free Exercise Clause of the First Amendment. Similar or more severe restrictions apply to comparable secular gatherings, including lectures, concerts, movie showings, spectator sports, and theatrical performances where large groups of people gather in close proximity for extended periods of time. And the order exempts or treats more leniently only dissimilar activities, such as operating grocery stores, banks, and laundromats, in which people neither congregate in large groups nor remain in close proximity for extended periods. The precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement. Our Constitution principally entrusts the safety and the health of the people to the politically accountable officials of the states to guard and protect. When those officials undertake to act in areas fraught with medical and scientific uncertainties, their latitude must be especially broad. Where those broad limits are not exceeded, they should not be subject to second guessing by an unelected federal judiciary, which lacks the background, competence, and expertise to assess public health and is not accountable to the people. This is especially true whereas here, a party seeks emergency relief in an interlocutory posture, meaning while a case is still going on. In other words, case hasn't been lost and you're appealing in the middle of the case. The case is still going on and you're appealing. while local officials are actively shaping their response to changing facts on the ground. The notion that it is indisputably clear that the government's limitations are unconstitutional seems quite improbable. And so that's interesting there, because Justice Roberts is expected to go the other way. He's expected to lean to the conservative Republican side, and that was expected to lean towards the church, lean towards going against the governor's order. And here the justice has said, no, that's not what we're doing here, because this is the law. But how would it have gone if it went the other way is a question we can answer right now. Justice Kavanaugh, along with Justice Thomas and Gorsuch, dissent. Justice Kavanaugh writes, I would grant the church's requested temporary injunction because California's latest safety guidelines discriminate against places of worship and in favor of comparable secular businesses. Such discrimination violates the First Amendment. Now remember, this is the opinion that turns out to be wrong by one vote. In response to the health crisis, California has now limited attendance, as we saw above. The basic constitutional problem is that comparable secular businesses are not subject to a 25% occupancy cap, including factories, offices, supermarkets, restaurants, retail stores, pharmacies, shopping malls, pet grooming shops, bookstores, florists, hair salons, and cannabis dispensaries. Now, my answer to that is to look at the difference. A recent study said that people who sing in a choir are probably among the most able to transmit the virus. And that's what I was doing in Luxembourg. So in middle of January and all throughout February, I was singing with a choir in Luxembourg. Well, when you're singing, you're projecting your voice, you are enunciating your diction, you're pronouncing things. So you're spitting little bits of spit into the air as you are singing, and everybody's doing this in a closed room. Everybody is facing the same direction, standing in close proximity, basically shoulder to shoulder, and spitting into the air while projecting their air out of their lungs continuously. So what do you do in church? I mean, I know not everybody sings in church, but you speak out loud, you stand shoulder to shoulder, you face the same direction, you all project your air and your spit and everything into this closed room of people. Is that the same thing as a factory? Are you singing or speaking into the air at a factory? I mean, I guess you could be, depends on the factory, so maybe some measures have to be implemented. An office, okay, same measures could be implemented. Supermarkets, I don't speak to anybody at the supermarket. Restaurants, I don't know that restaurants are open, but okay. Retail stores, again, aren't really open, but you're not standing around singing into the air. Pharmacies, shopping malls, pet grooming, bookstores, florists, you're not standing around singing into the air. Hair salons, okay, you're sitting there for a while interacting with one person who's touching your head. Okay, maybe there could be a restriction there. Cannabis dispensaries, no, same as everything else. You go in, you get what you need, you leave. South Bay United Pentecostal Church has applied for temporary injunctive relief from California's 25% occupancy cap on religious worship services. Importantly, the church is willing to abide by the state's rules that apply to comparable secular businesses, including rules regarding social distancing and hygiene. But the church objects to a 25% occupancy cap that is imposed on religious worship services, but not imposed on those comparable secular businesses. Again, I don't think that they're that comparable. I mean, here's where we are, is like some lowly attorney is disagreeing with the Supreme Court. And it seems like it's a valid disagreement because somebody who was on their side flipped over to the other side to join the side that agrees with the social distancing and the 25% cap and all that. In my view, California's discrimination against religious worship services contravenes the Constitution. As a general matter, the government may not use religion as a basis of classification for the imposition of duties, penalties, privileges, or benefits. This court has stated that discrimination against religion is odious to our Constitution. To justify its discriminatory treatment of religious worship services, California must show that its rules are justified by a compelling government interest, narrowly tailored to advance that interest. That is constitutional strict scrutiny and does apply to infringements of the religious right. California undoubtedly has a compelling interest. Great. In combating the spread of COVID-19 and protecting the health of its citizens. But restrictions inexplicably applied to one group and exempted from another do little to further these goals and do much to burden religious freedom. What California needs is a compelling justification for distinguishing between, 1, religious worship services, and 2, the litany of other secular businesses that are not subject to an occupancy cap. And I think I just explained it. In church, you are side by side, you are singing, you are simultaneously opening your mouth and breathing while spitting out. Like you are singing out, you are speaking out, you are chanting, you are amening, you are and also with youing is the other one. You are praying, you are doing all these things out loud with your voice, with your air from your lungs, with your little droplets of spittle and mucus and stuff in them. And you're all doing it facing the same way, and you're all doing it breathing in at the same time because you're singing, yada, 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 yada. You're all doing it at the exact same time. California has not shown such a justification. I think they have. The church has agreed to abide by the state's rules that apply to comparable businesses. This raises important questions. Assuming all the same procedures are taken, why can someone safely walk down a grocery store aisle but not a pew? Because I'm not singing out loud while I'm walking down a grocery store aisle. I mean, I'm not. Maybe you are. And why can someone safely interact with a brave delivery woman but not a stoic minister? The brave delivery woman is interacting with you for a second, and you are only, and they're usually wearing a mask, and you're only grabbing a box from them. That's it. Like, you're interacting with them for like the shortest amount of time, and you're trying not to interact with them. Whereas in a pew in church, like, the interaction is the point. The church and its congregants simply want to be treated equally to comparable secular businesses. They are. In fact, remember, they're tax exempt. They are not tax-paying businesses. California already trusts its residents and any number of businesses to adhere to proper social distancing and hygiene practices. That's fair. The fact that the church pledges to adhere to social distancing practices is fair. That's great. I still disagree with the overall outcome, or rather with the overall dissent. I agree with the overall outcome. I agree with the concurring opinion. Just social distancing isn't enough, I don't think. The state cannot assume the worst when people go to worship, but assume the best when people go to work. Again, they are not, maybe somebody works with a choir. Maybe there is an argument to be made that there is a choir where people go to work and they sing in their choir and they don't have these restrictions visited upon them. Yeah, that's unfair. So personally, I think this should apply to any place that people congregate and sing or chant or speak or anything, protest, that these rules should apply. Could the rule be revisited so that it doesn't implicate the Supreme Court? Sure, maybe. California has ample options that would allow it to combat the spread of the virus without discriminating against religion. The state could insist that the congregants adhere to social distancing and other health requirements and leave it at just that, just as the governor has done for comparable secular activities. Or alternatively, the state could impose reasonable occupancy caps across the board. But absent a compelling justification, which the state has not offered, the state may not take a looser approach with, say, supermarkets, restaurants, factories, and offices. Now, if Justice Kavanaugh is correct, the state has not offered these arguments. Okay, fair point. The state should be offering arguments like, hey, we've seen all these examples over the last 8 weeks or three months or whatever it is. We've seen all these examples. I've lost track. I don't even know what day it is sometimes. We have all these examples of people going to church or people assembling in large gatherings, and then we have an outbreak specifically from those very people. So what was it? The one church had a gathering and something like 20 people died or something from the gathering, like not instantly, but over the next month. Many people died from the gathering. It's being in that close proximity. So maybe the state could have done a better job, and that's definitely a very valid argument. If the state does not articulate the compelling governmental interest that is narrowly tailored, then yeah, they probably lose on this. The state also has substantial room to draw lines, especially in an emergency. As relevant here, the Constitution imposes one key restriction: the state may not discriminate against religion. Well, the state may discriminate against religion. It must do so in a way that is compelling. It advances a compelling interest and is narrowly tailored to advance that interest. That's when it may discriminate against religion. In sum, California's 25% occupancy cap on religious worship services is indisputably discriminates against religion, and such discrimination violates the First Amendment. The church would suffer irreparable harm from not being able to hold services on Pentecost Sunday in a way that comparable, say, is today Pentecost Sunday? Is that what we're doing right now? Secular businesses and persons can conduct their activities. I would therefore grant the church's request for a temporary injunction. I respectfully dissent, says Justice Kavanaugh. Of course, we are not infallible. We are not final because we're infallible. We're fallible because we're infallible because we're final. So in other words, the majority opinion from Justice John Roberts, his concurrence, was part of a majority decision, and that majority decision rules, and there's no appealing that. That's it. So that's the decision. And the California governor's 25% occupancy cap or 100-person occupancy cap remains in place. Could it have been done better? Yeah, I 100% agree that it could have been made clearer if what Justice Kavanaugh is saying is true, that the government made no showing of what alternatives it explored or applied, what restrictions could have been applied secularly instead of just to religious activities. I don't know. If the government really did make no showing, then yeah, that would support Justice Kavanaugh here. But Justice Roberts was not so swayed, so I'm not so swayed either. Let me know what you think in the comments below. I am all for all of you attending every church service you want. What I'm not in favor of is keeping the country under coronavirus lockdown because you could not avoid social gatherings in the form of church services for 2 months. Like, 2 months should have been enough to completely wipe out the virus, but obviously we didn't do a good enough job here in the States. So now it goes on for longer. I don't see how avoiding social distancing and instead going to a social gathering, even if it's for religious purposes. Like, my very religious parents are doing religious services via Zoom. My mom is on the board of the church. She helps run the church, and she's fine with doing Zoom services. I set it up for her, and she figured out how to use Zoom. Great job, Mom. If my mom can do it, your mom can do it too. Hey, I've been sheltering in place for 2 months, and I would very, very much love to see some of my favorite things reopen too. So that is our show. Thank you for joining me, everyone. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite community-supported legal news and education channel. Community-supported means we need your financial support in order to keep this effort going and keep making you new videos on modern or contemporary legal news and education. Thank you to the following June $50 plus supporters: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian Hellman, Jay Dixon, Ameknight, and Oscar the Prophet. Thank you so much for your support. Thank you to the $5 plus supporters who are scrolling on the LED panel next to me. All of you will appear on the crawls in front of me and in the description of the videos that drop. I'm Leonard French. I love you all. I honestly can't believe. Do you remember the end of My Cousin Vinny when Marissa Tomei turns to Joe Pesci and says, "What a nightmare. At the end of everything you do, after winning every court case for your entire career, you have to turn to somebody and you have to say, thank you." You know what? Thank you. You guys are wonderful. This is an amazing community, and I'm so happy to be a part of it. I'm Leonard French. I love you all. I'll see you in the videos that drop. Thank you.